Parliamentary sovereignty is dead. Long live judicial supremacy under this constitution. So for some reason ChatGPT didn't think that those rights were important enough to include in this document. But this does suggest to me that ChatGPT doesn't really understand the British Constitution. Hi everyone, I thought I would do a fun experiment and ask ChatGPT to draft a written constitution for the United Kingdom. Now, the purpose of this experiment, like I said, it was just a bit of fun, but I thought it would help as well give a bit of an insight into ChatGPT's understanding of particular aspects of a country's constitution, of a country's public law. So basically, is ChatGPT coming for my job? Before jumping into that draft, ChatGPT just set out a bit of background to the UK constitution, that the UK has an uncodified constitution. And if it were to have a codified constitution, it would look something like what the Germany or the United States has. It clarifies as well here towards the bottom that it's a foundational draft, that it's one that's ideal for discussion and refinement. So first things first, we have a preamble, and all good constitutions start with a preamble. Very straightforward, generic here. It's the constitution is being given by the British people. That's interesting here. I think there's nothing here about the role of the monarchy. There's nothing about the king. This constitution comes from the people. Now, Article 1 and Article 2. The United Kingdom is a sovereign democratic state comprising of 4 nations, England, Scotland, Wales and Northern Ireland, and sovereignty resides in the people of the United Kingdom rather than in Parliament or rather than in the monarchy. It's a very clear expression that this UK under this constitution is a democratic constitution with power coming from below rather than coming from high, being vested in a monarchy who's anointed by God. And if you look at the coronation around King Charles, you would see that a lot of that religious imagery is very much present in that. There's nothing to do with religion or the monarchy in this preamble. It all comes from the people. Then we've got Article 2, which emphasizes the rule of law. Rule of law isn't really clarified or explained. There's nothing inherently wrong with that. Lots of constitutions contain very, very vague concepts. Part 2 then is fundamental rights. And I think this is where we're beginning to get something a little bit interesting here. So the rights that we have here are liberty and security of the person, freedom of thought, expression, religion and belief, freedom of assembly and association, the right to fair trial, protection from discrimination, the right to privacy and family life. So those are all kind of classic rights that you might see in a document like the European Convention on Human Rights. Interestingly, what's missing from this is the right to life. And there's no mention on the prohibition on torture. So for some reason, ChatGPT didn't think that those rights were important enough to include in this document. Now, it might be because in this section, it talks about the proportionate limitation of these rights. And certainly those kind of limitations don't apply to things like the absolute prohibition on torture. There's no proportionate interference with that right. It's an absolute right. So perhaps that's why that's not included here. I think what's really interesting is if we go down towards the bottom here, is that the Constitution is expressly safeguarding economic and social rights, including access to education, healthcare and an adequate standard of living. Does this mean then that these rights are legally enforceable? Does this mean that you could take the government to court for not adequately protecting these rights? Normally, those kind of what we call socioeconomic rights are non-justiciable. They're not the kind of things that can be enforced by a court. Why? Because courts tend to take the view that these are political or disputes that need to be resolved by the democratic branches, because they usually put a lot of demand on resource allocation. Then we go on to Article 4 and Article 5. So Article 4, equality before the law, that's fairly standard. Again, this is quite vague, but human rights law tends to be quite vague, or at least the broad principles set down in treaties and in constitutions tend to be quite broad, and it's up for courts then to come along and flesh them out and explain what they mean. But then we move on to Article 5. The rights contained in the European Convention on Human Rights shall be incorporated into this constitution and shall be directly enforceable. So there's a lot in here. So firstly, Article 5 seems to be doing or referring to a lot of the rights that are already included in Article 3 in the previous section. And so there's a bit of a copying, pasting, a bit of an overlap here. It's unclear why it felt that this was necessary. It's unclear as well what it means by the rights in the European Convention on Human Rights and the Human Rights Act. So most of the rights have been transferred across, but not all of them. So for example, Article 13, which is the right to an effective remedy, wasn't incorporated by the Human Rights Act into UK domestic law. This seems to be suggesting perhaps that all of those rights in the ECHR should be copied and pasted across. It's also unclear what it means by directly enforceable. Does this mean that the judiciary is able to enforce these rights not just against the government but against Parliament too? So the next bit is the Crown. The UK is a constitutional monarchy, and the monarch shall be ceremonial head of state and shall act in accordance with the constitution and on the advice of elected ministers. So this is the first time we've got a mention of the Crown. It's establishing the monarchy as a purely ceremonial role. Crown needs to exercise its power on the advice of the ministers. That would suggest therefore that the Crown has no discretion and they must do what the ministers advise them to do. If you look at the Irish Constitution has some similar wording in there with regards to the powers of the President, and most of these powers can only be exercised on the advice of the government, and that emphasises the fact that they don't actually have discretion. So there's a bit of a similarity between this clause and between what's in the Irish Constitution. So we have Article 7 and we're talking about Parliament. So Parliament shall consist of two chambers. The House of Commons elected by the people. That's absolutely fine. That's currently what we have. And the House of Lords reformed as a second chamber representing the nations and regions. So I think that's really interesting. It's not the existing House of Lords. And this sounds very like what was proposed in the Labour Party's Brown Commission report. So this was a commission chaired by Gordon Brown that analysed the UK's constitutional system and proposed a new revised upper House of Lords, and it called it an assembly of the nations and regions. It's a little bit unclear as to how that would be what that would consist of, but nevertheless it's interesting that ChatGPT seems to be mirroring that. So I'm wondering whether it has actually pulled from that document and has copied and pasted it over. It's unclear what the composition of this Lords would be. Would the government be able to appoint people, or are they going to be directly elected? Nevertheless, so did the Brown Commission's report leave that unclear as to how exactly this new upper chamber that's supposed to represent the views of the nations and regions of the UK, how they would actually be picked. Now, I think actually when we move on, we see that this is where it gets quite confusing. Article 7 states that Parliament should have legislative supremacy except where limited by this Constitution. No law shall be enacted that infringes upon the rights enshrined in this Constitution. So this section I think is quite unclear. What do we mean by legislative supremacy? So it might suggest something similar to parliamentary sovereignty. So currently in the UK, under its doctrine of parliamentary sovereignty, the Parliament in Westminster can make or unmake any laws it sees fit. So for example, a court cannot invalidate an act of Parliament if it violates human rights. That law is still valid. This section seems to suggest that although it's claiming that Parliament has legislative supremacy, it's also saying that Parliament doesn't have the power to pass laws which are in contravention of the Constitution. So does that mean therefore that courts are empowered to strike down legislation? So this is a radical departure from the existing UK constitutional order. In fact, I would argue that it's not just a radical departure, it's fundamentally irreconcilable with the existing UK constitutional order. So this does suggest to me that ChatGPT doesn't really understand the British Constitution. And when it's pulling from all the different sources that it's used to draft this constitution, it's completely misunderstood the absolute fundamental foundations of the British Constitution. So we move on then to the executive, and we have that the executive authority rests with Prime Minister and Cabinet. drawn from and accountable to Parliament. That's fine. Executive authority is not defined, but most constitutions don't define it. It's probably the power that's the most difficult to define. It's kind of like a wastebasket power that's basically all the powers of the state that aren't the judicial power or aren't the legislative power. We've got essentially here a codification of the existing convention that the Prime Minister is appointed by the monarch based on the ability to command the confidence of the House of Commons. Article 9, then we have the judiciary. It'll be the independent and impartial. The Supreme Court is the highest court. Again, there's nothing controversial in this until we get to the third section. And the third section states that courts shall have the authority to review legislation for compatibility with this constitution. So there we have it. We have the power of the court to judicially review legislation passed by Parliament. And that's a radical departure. That's telling me that ChatGPT doesn't really understand the British Constitution. Moving on then, we've got devolved nations and local government. Express protection for the Parliament or Assembly in Scotland, Wales and Northern Ireland, with lawmaking powers in defined areas. Moving on then to the part 2 is that the devolution settlement shall be constitutionally protected and cannot be altered without the consent of the respected nation's legislature and people. So this is suggesting that any change to the devolution regimes, it needs both the approval of the legislature and the people in those parts of the UK. Now that might be an attempt to safeguard or to prevent Westminster Parliament from taking powers away, but that's also potentially a barrier as well to further conferrals of power, to further devolution of power. It's also unclear then as to why this is devolution and not federalism. It's still using this language of devolution, and so it's drawing again from lots of stuff that's written on the UK on devolution. But the difference between devolution and federalism is that in a federal state like the US, there are separate and discrete competences for both the US government, so Washington DC, and then the government in the states, for example, Texas, New York. There are some things that the states cannot do that the central government can, and vice versa. There are some things the central government cannot do that the states are allowed to do. That can't happen in the UK because of parliamentary sovereignty. Parliamentary sovereignty essentially states that there's nothing that Westminster cannot do. And for that reason then we have devolution, where Westminster is essentially delegating some of its power to the devolved institutions, but Westminster could still exercise that power if it saw fit. It just, for the most part, decides not to, and that's constrained by convention, by political constraints rather than by legal constraints. But legally speaking, Westminster could still legislate in these areas if it saw fit. This constitution seems to be stating that Westminster cannot legislate in areas of devolved competences without first the consent of, say, the people in Scotland and the Scottish legislature. If that's the case, then that this is a fully federalised United Kingdom. This isn't devolution. And yet ChatGPT is still using this language of devolution. So again, this is quite confusing and tells me that ChatGPT doesn't really understand what devolution is, doesn't really understand the distinction between devolution and federalism. Then we have go on to local government, where constitutional protection of local government. I think this last section, local authorities shall have the powers and resources necessary to carry out their functions effectively. I think that's interesting because that's potentially creating grounds for judicial review. Say, for example, maybe a local authority could sue the central government, say the Westminster government, for not providing them with the relevant resources needed to deliver the services required. There would be a constitutional question in relation to that, and that could throw up big issues for things like austerity that we saw. So coming towards the end now, we've got a constitutional amendment procedure. So it may only be amended by a 2/3 majority in both houses of parliament and approval by a majority in a UK-wide referendum. So again, this is very clearly the abandonment of parliamentary sovereignty. This is very clearly setting the constitution as a superior text to ordinary legislation. And it's also a very, very difficult mechanism of amendment, that you need 2/3 majority in both houses, and then that you need a referendum. And I think this therefore would make this constitution very difficult to change. And that difficulty to change really runs against what is often considered to be the great strength of the UK constitution, which is its flexibility. So this goes completely against that. There's no reason why, for example, you couldn't have a constitution that's amendable by the ordinary legislative procedure. And that amendment process would very much be in line with the notion of parliamentary sovereignty and would be more in line with the existing UK constitutional tradition. ChatGPT has chosen not to do that. It's gone for the other extreme. So again, I don't think this shows that ChatGPT really does actually understand the British Constitution. We move on again to Article 13, and very clearly we've got the supremacy of the Constitution and a very clear statement that any law or government action inconsistent with this Constitution shall be null and void. Again, parliamentary sovereignty is dead. Long live judicial supremacy under this Constitution. Then Article 14, these are just your typical transitional arrangements in the Constitution. There's nothing really too interesting or radical to be said about that. So really overall, my views on this is I don't think this reflects very well on ChatGPT. I don't think ChatGPT really does understand the British Constitution. Really the big red flag here for me is that complete abandonment of parliamentary sovereignty. My guess is that it's pulling from a lot of maybe generic constitutions or a lot of other constitutions across the world, and it's just copying and pasting a lot of that, applying it to the UK and changing some of the terminology, like talking about things like devolution instead of federalism. The reference to the Assembly of the Nations and Regions, I think that's pulling from the Brown Report. There are parts where the text isn't sufficiently clear and there are some overlapping sections. I don't think that's the end of the world. A lot of constitutions tend to be drafted in quite vague terms, and then it's up to courts to flesh out the meaning of this. So that's not unique. But the areas in which there is an overlap and a contradiction or an unclarity, for example, the part where it was talking about incorporation of the Human Rights Act after listing all these previous rights, I think there might be an issue there. The best description I've heard of with regards to ChatGPT is that they're like parrots. A parrot can mimic a human voice, but it doesn't actually understand the words that it's saying. And I think this experiment underlines that. ChatGPT is able to mimic what a constitution would sound like. It's able to mimic certain words that are used in British constitutional discourse. But the way it's put all of this together demonstrates to me that it doesn't actually understand what it is that it is saying. And I think that underlines just the inherent unreliability of AI when using it for legal writing and using it for legal research. It's very good at producing things that sound plausible, but just a little bit of knowledge, a little bit of understanding, and a little bit of insight reveals actually that there's not really much holding that up. Now, I didn't ask it any further questions. I didn't ask it to do any further refining, and so some defense of ChatGPT that maybe I will get in the comments is to say, well look, this was just a rough draft. You're supposed to come along and ask it more questions, tell it to add this, tell it to take away this, and tell it to refine that. Now I could have done that, but the point of this exercise was really just to give you an insight into what ChatGPT is doing with a very, very raw prompt. And in order for you to refine it, you do need to have a sufficient degree of knowledge and insight into the operation of the UK Constitution. And I think that's the main insight from this video. It can't replace the background knowledge that you need to make this work properly. So I think this is a good exercise to show the limits of ChatGPT in helping you, say, in your legal research or your legal education. So if there's any insight I can get from this, it's that it might be a time saver, but it's not a knowledge giver. And you can't get that background knowledge from ChatGPT itself. You can only get it from other sources. Thanks so much for watching. If you enjoyed the video, I would appreciate it if you could give it a thumbs up and subscribe to the channel for more content like this. If you have any thoughts or questions, please leave them in the comments below. I'd love to hear from you. Until next time, take care, and I'll see you in the next one.